Good morning. Welcome to VLearn. VLearn में आपका स्वागत है. Topic for today's discussion is mergers and acquisition, and we would be covering session 11, that is legal and regulatory framework of mergers and acquisition. Topics to be covered are introduction, Companies Act 1956, buyback of shares, objectives of buyback and guidelines for buyback of shares, SEBI's Act 1992 and SEBI Regulation 1997, Income Tax Act 1961, Foreign Exchange Management Act 1999, Listing Agreements. Introduction. In this unit, we will be going to study the various key provisions of Companies Act 1956, SEBI's Act 1992, Income Tax Act 1961 and Foreign Exchange Act, which is applicable on mergers and acquisitions. Companies Act 1956. In Companies Act 1956, there are only 7 sections which are from 390 to 396, which are related to the matters pertaining to mergers and acquisitions, and they have been discussed, and the Act lays down various legal procedures for mergers and acquisition. The first is permission of the merger. Here, 2 or more companies, they can amalgamate, they can join hands together only when the amalgamation is permitted by the memorandum of association of their company. Furthermore, the acquiring company, they should also have the permission in their object clause to carry out business of the acquired company. Also, in the absence of these provisions in memorandum of association, it is very necessary to seek the permission of the shareholders or board of directors and the company law board before actually effecting the mergers. Second is information to the stock exchange. In this scenario, both the acquiring and the acquired company, they are required to inform the stock exchanges in whichever stock exchange they are listed about the deemed merger. Another is approval of board of directors. Here, the board of directors of the individual company, they should have the approval and they should approve the draft proposal of the amalgamation and authorize the management of the company to pursue the proposal. The next is application in the High Court. The application, the draft for approval of the amalgamation, it should be properly, when approved by the board of directors of the individual company, they should be made present to the High Court. Shareholders and creators meeting. The individual companies should hold separate meetings of their shareholders and creditors for approving the amalgamation scheme. In this case, at least 75% of the shareholders and creditors in their separate meetings should vote in pursuit or by proxy. They must accord their approval to the scheme. Sanctioned by the High Court. After the approval of the shareholders and the creditors, and on petition of the companies, the High Court will pass an order sanctioning the amalgamation scheme after it is satisfied that the scheme is fair and reasonable. Also, the date of the court's hearing will be published in 2 newspapers, and also the regional director of the company law board will be intimated about the same. Filing of the court order. After the court order, the certified true copy will be filed with the registrar of the companies. Transfer of assets and liability. The assets and liabilities of the acquired company will be transferred to the acquiring company in accordance with the approved scheme with effect from the specified date. Payment by cash or security. As the proposal, the acquiring company will exchange the shares and debentures and or cash for the shares and debentures of the acquired company. These security would then be listed on the stock exchange. Buyback of shares. So there are certain provisions which are regulating buyback of shares, and in the Companies Act 1956 they are contained in section 77A, 77AA and 77B. These were inserted by Companies Amendment Act 1999. The Security Exchange Board of India, they have also framed SEBI Regulations 1999 for buyback of securities, and the Department of Company Affairs framed the Public Limited Company and Unlisted Company for the buyback of securities rules in 1999. When we talk about the objectives of the buyback, there are situations why and how the buybacks are done. So shares may be bought back by the company on one or more of the following reasons. First reason is that if the company wants to increase the promoters' holding in the acquired company and in the total corporate entity, then buyback is carried out. Also, buyback is done with a view to improving and increasing the earning per share capability. Furthermore, the rationalized capital structure by writing off capital not represented by available assets. This is also a result why buyback is done. Furthermore, to support the share value of the existing shares, the buyback is done. The fifth is to thwart takeover bid, and the last is to pay surplus cash which is not required by the business. In fact, the best strategy to maintain the share price in a bear run is to buy back the share from the open market at a premium over the prevailing market prices. There are certain guidelines, there are the conditions for buyback of shares. The first is a buyback of share, it must be authorized by the Article of Association of the company. So Article of Association should authorize the company to buy back the share. If it does not have that provision, the Article of Association, the company cannot carry forward with the buyback of shares. Another is a special resolution must be passed in the general meeting of the company authorizing them to buy back. And in case of listed company, this approval is required by means of a postal ballot. Also, the shares for buyback, it should be free from lock-in period or non-transferability. The buyback can also be made by the board of directors. Where the buyback is of less than 25% of the total paid up capital and free reserves of the company, and that the buyback of equity share in any financial year, it shall not exceed 25% of the paid up capital in the financial year. The ratio of the debt owned by the company, this is one more guideline, is not more than the twice the capital and its free reserved after such buyback. So it's a guideline after the buyback. The ratio of that is debt owned by the company over the capital or free reserve, it must be 2:1 ka ratio. Another is there is no default A in payment of deposits or preference shares, B in redemptions of debenture or preference shares, C payment of dividend if declared to all shareholders within the stipulated time of 30 days from the date of declaration of dividend. Fourth is repayment of any term loan or interest payable thereon to any financial institution or bank. Another guideline, another condition which accounts for buyback is there is no default in complying with the provisions of filing of annual return. Company does not default in any of the provisions in complying with filing of income tax annual return, payment of dividend, and forms and contents of annual account. Also, all the shares or other specified security for buyback, they are fully paid up in nature. The last is the buyback of the shares or other specified securities listed on any recognized stock exchange. They shall be in accordance with the regulations made by SEBI in this behalf. When we talk about SEBI Act 1992 and SEBI Regulation 1997, SEBI regulation called the Security and Exchange Board of India, that is substantial acquisition of shares and takeovers, Regulation 1997, deal extensively with the rights of shareholder. However, the rights of shareholders are interlinked with the duties of these. Some of the highlights, they are listed, we will be discussing it right now. So under SEBI takeover code, any person acquiring 10% or more of the voting capital of the company or securing the control of the management of the company by agreeing to acquire, irrespective of the percentage of voting capital, the securities of the directors or other members who control or manage the company, has to make an offer to the remaining shareholders of the company to acquire from them an aggregate minimum of 20% of the total shares of the company. Also, a point is to be noted, no acquirer shall acquire shares of voting rights which entitles such acquirer to exercise 10% or more of the voting rights in the company. There are various contents of a public announcement of offer that should also be included. First, the paid up share capital of the target company and the number of fully paid up and partly paid up share. The second is the total number and the percentage of shares proposed to be acquired from the public should be subject to minimum as specified in sub-regulation 1 of regulations 21. The minimum offer price for each fully paid up or partly paid up share, the mode of payment of consideration, the identity of the acquirers and in case the acquirer is a company or companies, title, identity of the promoter and or the persons having control over such companies and the group, the existing holding, if any, of the acquirer in the share of the target company, including holdings of person acting in the concert. When we talk about Income Tax Act 1961, it also defines some of these concepts, but being limited in scope, it cannot be lifted and read in the Companies Act. Section 21B of Income Tax Act, it defines amalgamation in relation to companies as the merger of one or more companies with another company, or the merger of two or more companies to form one company in such a manner that all the properties and liabilities of the amalgamating company become the property of the amalgamated company by virtue of the amalgamation. Here the eligibility carrying out forward and check concession is contingent upon the amalgamated company holding continuously for a minimum period of 5 years from the date of amalgamation. Furthermore, it also provides the act that the acquisition of the property of the company by another company pursuing the purchase of such property by the other company or as a result of distribution of such property. Demerger of companies under Income Tax Act 1961. The Companies Act 1956 does not define demerger, but Section 2 brackets 19AA of Income Tax Act define merger in relation to companies means the transfer pursuant to a scheme of arrangement under Section 391 to 394 of the Companies Act 1956 by a demerged company of its one or more undertaking to any resulting company. The manner of transfer requires that all properties and liabilities of the undertaking being transferred by the demerged company become the property of the resulting company by virtue of the demerger. The transfer of properties and liabilities, they have to be done at the book value appearing in the books of accounts of the demerged company. When we talk about listing agreements, so they are governed by the key provisions. First is the merger. So the listing agreement whose share are listed on stock exchange to make relevant and timely disclosure of price sensitivity information. So such information would include any decision taken in respect of merger. When we talk about acquisition, so the provisions of takeover, they are regulations which are applied in any case involving substantial acquisition of shares in a company whose shares are listed in the stock exchange. Further, the takeover regulations they do not apply in cases of the allotment of shares in a public issue. On second, the preferential allotment of shares made to any person in terms of an authorization made by shareholder passing a special resolution. And the last is inter-transfer among Indian promoters and collaboration. In addition, The SEBI may grant some exemptions from the provision of takeover regulation in certain cases based on fact of the cases. So there are some obligations on the part of the acquirer and the target company. So the first is obligation to disclose. When we say obligation to disclose, so any person who has acquired more than 5% of the shares or voting rights in a company, within 4 days that person is required to disclose all the facts to the target company, and likewise the target company is also required to disclose all the information and all the facts to the stock exchanges. Another is obligation to make a public offer. This states that no acquirer can acquire more than 15% of the shares or voting right in a company unless it makes public offer to acquire a minimum of 25% of the voting capital of the company. 2 exercises. What are buyback of shares? Explain the objectives and guidelines for buyback of shares. The second is what are the listing agreements. Thank you and have a nice day. Keep learning and relearning.